SJC-13344, Commonwealth versus Dewane M. Say. Attorney Sheketoff.
Good morning, Your Honors. Robert Sheketoff for the defendant appellant Dewane Say. I've raised only one issue, the motion for required finding of not guilty. I believe, and this court will correct me if I'm wrong, that this case is controlled by your recent decision in Commonwealth versus Baez. In any event, the Commonwealth conceded in its opening statement that their theory of the case was that the defendant was the driver of the vehicle that the shooter got out of and then shot the victims. And in order to get a conviction on that theory, they would have to show that my client was in fact the driver, that in fact the car that they focused on that he had rented.
So if we cut to the chase in a light most favorable in looking at Baez and Baxter, which are really the cases I think in everyone's mind, can we say in a light most favorable you lose on participation given the GPS and the car coordinates, but your issue is on shared lethal intent?
So I think that is my best issue, shared legal intent, but I don't think I lose on the on the participation either.
Convince us then, I guess.
Okay, this is why. This car rented from Maven, which was some sort of car sharing service that doesn't exist anymore, requires a cell phone of the person that rents it. This is the testimony at trial, to turn it on. So if I'm going to loan this car to somebody as the person that rented it, I have to give them my cell phone too. Otherwise, you can't turn the car on. And in this case, the car was turned off immediately after the shooting, and it stayed off for approximately 25 minutes, and then it was turned on again. When it's turned on again, it's found some distance, but not that far a distance from where the shooting took place. So no one saw anyone in this car. There's video of the car. Obviously, I would suggest the Commonwealth can prove this beyond a reasonable doubt, following the victim's car. But it's unclear who was in that car.
You have two bookends of him renting the car. At least he's on video, right?
Right, but one is...
renting the car and returning the car.
Right. One is him renting the car. Arguably, it's him. You can't really tell for sure, but someone similar to him renting the car 2 days earlier and returning it an hour afterwards.
Can I ask about the 2 days earlier?
After the shooting, I'm sorry.
After the shooting, yeah.
Can I ask, there's a statement in the Commonwealth's brief that I'm going to ask your sister about, but the gray car eventually drove away without this person. Does the person who rent the car transfer the car and the key to someone else on August 12th? Is that what that statement is saying? There's a reference, I read the transcript references and the exhibit references. I can't follow it because you have to watch the video, which I haven't done yet.
Okay. There's no evidence in the case that he was driving the car, and there's no evidence in the case that he loaned the car.
That's a very particular question.
Yeah, there's
On
no...
August 12th, I think the evidence is he rented the car.
Right.
But when I read her brief, it suggests that he transfers the car to somebody else on August 12th, but I may be misreading the brief.
So I don't think that's the Commonwealth's position,
Okay.
But they can speak for themselves. There's just no evidence on this topic of whether he ever loaned the car to somebody else or was driving it on the date in question.
But counsel, I mean, again, I know you're saying you're not giving up the participation prong, which I don't think is a very strong argument for you, but nevertheless, you still have CSLI from the phone that's attributable to your client in the area before the shooting.
That's correct, Your Honor, but in the circumstances of this case, if I'm going to loan this car to somebody, I also have to give them my cell phone.
I thought you had to just download an app onto your own cell phone. Maybe I've mistaken the facts there.
So whatever we might think of this testimony, the testimony is actually clear. In order to, according to the Maven expert, in order to turn this car on and off after downloading the app, you need the cell phone that downloaded the app. It connects to that phone number. So
Why, I'm just follow the thought. Why can't that be the defendant's phone?
well, it is the defendant's
Oh,
phone.
okay. All right. I thought
I'm
you were
not saying
suggesting
it's
it was
not the
somebody else.
defendant's phone. I'm saying that if he loans the car to
He
somebody,
owns the phone and owns the car.
Yes.
The phone being the key, essentially.
the phone is the key to the car. You can't turn the car on and off without the phone, and this car is turned on and off. In fact, it's turned off right at the exact moment of the shooting and stays off for 20-something minutes. No one sees my client in that car that day. There is a picture of someone that resembles my client returning the car an hour after the shooting. No one ever sees a second person in the car, ever. No one sees a person leave that car and walk down the street. That's inference on inference. And no one sees the shooter get back into the car. Whether this car was involved in any way other than following this vehicle is, I suggest, speculation.
Okay, I know you're going to say that you can minimize this, but again, the framework still is in the light most favorable to the Commonwealth. You also have, when the police went to go interview him, he conceded that he's rented Acadias before, both blue and red. And again, I know you're going to say that that doesn't amount to anything other than inference upon inference upon inference, but at least with the participation part, I think we all really are interested in the shared legal, we get your point on that. The shared lethal intent part is the part that really is where the rubber hits the road. I know we say that there's Baxter and there's Baez, but here the Commonwealth lays out through the surveillance videos, through the CSLI, through the information with respect to who rented it and what was done right after, an hour after the shooting, that it was returned. Why isn't this a little bit more than what we had in Baxter and Baez?
So I would suggest it's a little bit less than you had in Baxter and Baez because there's no evidence. First of all, in terms of returning the car, it had to be returned that day.
Mm-hmm.
Maybe it's a couple hours early, but it had to be returned that day. There's no motive for my client.
Mm-hmm.
There's no evidence of who the second person was. What my client's assuming it was him that was driving, what my client's relationship with that person would be. There's no suggestion that that person ever said anything about wanting to kill this person. There's no evidence that a gun was shown to my client. There's no evidence that there was any talk about doing anything to this person before it happened. And there's no evidence that the shooter got back into the car afterwards. I think Baez is a stronger case for the Commonwealth than this case is, because in Baez, he clearly picked up, in the light most favorable to the government, he clearly picked up the two shooters after the shooting. So I don't see any basis for inferring a lethal intent for my client. As this court has said before, even if you can infer an intent to do some sort of harm to the victim, in order to get a first-degree murder conviction or or assault with intent to murder conviction, you have to show a lethal intent. Mm-hmm. There is just total guesswork to suggest that, I would argue. So I can't emphasize enough that in the unique circumstances of this case, the CSLI does not put my client at the scene, because if he loaned the car to somebody, which is a common phenomenon in Swafford, Mr. Gittens was the owner of the car, and that was not enough, because no one could say that the driver looked like Mr. Gittens, or and Gittens had a motive in that case. I suggest that you can't even put my client in the car, and you certainly can't put the shooter in the car. But I concede that my best argument is the state of mind. Thank you.
Okay, thank you. Attorney Paris.
Good morning, may it please the court. Molly Paris on behalf of the Commonwealth, asking that this court affirm the defendant's convictions. I'd like to start out by distinguishing this case from Baxter and their.
Could you just start out with the fact question? I just don't know what you're saying on page 18 of your brief. Are you saying that, I just don't know what it means, the gray car eventually drove away without this person? Does that video show that somebody else went off with the car after he rented it?
So what the video shows is a gray car pulling into the front of the government center garage, the defendant exiting the car, leaning forward to speak with whoever was driving, and then the defendant then walks into the government center garage, and there's video captured of him walking down the hallway past the kiosk. So that gray car is just
So it's
someone who
not the
dropped him
car
off.
we're dealing with, it's a totally separate car. right?
Exactly, totally
I
separate,
just
yeah.
got confused.
And that's
Okay.
at about 2:16 on August 12th,
Okay,
2 days before the murder and about 5 minutes before the rental. So turning to the three reasons why this case is factually distinguishable, the first is that the defendant was hunting the victims for about 2.5 hours in Mattapan Square prior to spotting the victims. The second is the aggressive following, the pursuit from Mattapan Square up Blue Hill Avenue to Deering Road. And the third is that the shooter was outnumbered 2-1.
But in Baez, we had this hunting down, right? So if my memory, I meant Baez, I mean Baxter, we had hunting down essentially, right?
Yes, Your Honor. But in that case, the court found that the maneuvering alone was insufficient. And here, the Commonwealth's position.
You have longer maneuvering in this case versus the maneuvering in Baxter.
Exactly. It's not only longer in terms of time, but in terms of geographic location. If you look at the maps, you can see the relation from where Mattapan Square is.
But how is that relevant for lethal intent when it could be relevant to intent to do some type of harm?
Right.
Well, it's relevant when you take it in conjunction with the fact that the shooter is outnumbered 2-1. And as this court found in Baxter and Baez, in those cases, the shooter and victim, it was a 1-to-1 ratio and both were on foot. And the court expressed.
Baxter, there were two
There were two shooters, yeah.
co-defendants who
Right.
ultimately killed the victim.
I believe there was one shooter who.
And there was a witness that testified that there were two people that ran back to the car, and one got into the passenger seat, one got into the back. So there were two people on the street. But irrespective of that, going back to Baxter in the point that Justice Gaziano made, you really just, all of these things that you point out in your brief distinguish this case from Baxter. It's just maneuvering. Right? I mean, it's maneuvering that you're putting an overlay in, but it's still maneuvering of the car, and it's a little bit different than even, I'm blanking on the name that came after Baxter, the appeals court case. It's different than, I think it was Saunders or Sanders, where at least in that case, they said the maneuvering, you could still infer the lethal intent because whoever shot at the other car was in the car that maneuvered in the way of the people that were ultimately shot. This isn't a situation like that, where even if we give you participation, the car drives up, maneuvers, somebody shoots from inside the Acadia, and then you drive off.
Well, it's the aggressive maneuvering plus when you take into conjunction the reconnaissance, which is what this court considered in Watson, and also, again, the 2-to-1, which is the shooter being the one and the two victims in the
In
car.
Watson, there was a beef though, right?
And there's no evidence of motive here.
Correct, there's no evidence of motive. In Watson, I don't believe there was any evidence of motive. But regardless, just going back to the 2-to-1, this court explicitly expressed concern at oral argument in Baxter that if there was a one-on-one, wouldn't that equally likely mean that it was a street fight as opposed to a shooting? And here what we have is the shooter running directly down walking directly down Deering Road, walking alone, firing directly into the Lexus, and then sprinting immediately up Deering Road, heading in the direction of Wellington Hill Street. Seconds after the Acadia arrived on scene, and all of this happens while the Acadia puts, the GPS puts the Acadia outside of 85 Deering Road. So we know the jury.
What's the connection, if any, between the shooter and the Acadia?
The connection is the close geographic and temporal proximity. So we know the Acadia turns onto
So we
Deering.
don't have the shooter coming out of the Acadia or jumping back in?
We have video evidence of the shooter walking down Deering Road and then sprinting up immediately after the shooting.
But not to and from the Acadia?
No, but we have circumstantial evidence, and that's sufficient here. What we do have is video showing.
In Baxter, we actually had the shooter coming out of the car and then running back into it.
And the jury could infer that the shooter came from the car, given that the Acadia turned onto Deering Road a little after 9:41 in the morning, is then seen passing 56 Deering Road at 9:42.
Do we have any evidence about the number of cars at 9:30 in the morning?
In terms of the number of cars?
I mean, like, was it a dark, desolate area?
I believe maybe there was one other car shown on the, several minute video clip of 56 Deering Road. But an eyewitness testified that at the time there was no one else aside from the shooter who approached. So again, just to finish, after the Acadia passes 56 Deering Road, the GPS puts the Acadia outside of 85 Deering Road, which is just past the intersection of Deering Road and Wellington Hill Street, about half a block up, for 3 minutes. Then we see the shooter walking past down Deering Road in the direction of Blue Hill Avenue at about 9:45 in the morning. And seconds after the shooting, we see him sprinting back up, and that's all corroborated by eyewitness testimony.
Assume that we give you all of that, though. It's still the issue is the lethal intent. I mean, we said in Baxter, perhaps the jury could infer that that whomever was in the car driving intended something to happen to the person in that car. But what's the evidence that it was a lethal something to happen to that person in the car? We don't have all of the indicia that we've had in the other cases where there was a gun, we know there was a motive, there was some other plus factor that was proven to infer the lethal intent. How do we get lethal intent here?
We know it's lethal intent because there's two victims in the car, Darrell and Amato, and there's one shooter. And so the defendant stays at 85 Deering Road in this position of safety. He knows he doesn't have to get out of the car because it's going to be a quick, lethal ambush. And also the shooter's at a disadvantage. He's on foot relative to the two victims who are in the car, which makes it different from Baxter and Baez, where the shooter and the victim are both on foot. They're on equal footing.
So is the mathematics, though, the only thing that, because no one puts the shooter in the Acadia, no one puts the shooter in the Acadia after the shooting. So and no one knows what happens to the shooter after, right? Because they released a canine, they couldn't find anyone, they never found the gun, they never found the other person. So how do we connect that math, and wouldn't that be inference upon inference if we did?
I mean, that's certainly an inference, but the Commonwealth doesn't have to disprove all inferences. The most reasonable inference is that where there is no one in the area of Deering Road, according to John McIsaac, who was sitting outside of 34 Deering Road, which was about 2 or 3 car lengths beyond, closer to Blue Hill Avenue, but past the red Lexus, which was parked outside of 40 Deering Road. And what we have is the temporal and the geographic proximity, which is key, which is the closest thing we're getting to direct evidence, and circumstantial evidence is sufficient here.
We have temporal proximity in all these cases, in Baxter and Baez too. They're right close by. And even in those cases, there's a relationship between, there's a closer relationship between the driver and the people accused of being the shooter. Here they never found the shooter, right? It's just a total guess.
That's
By the
correct.
way, does the video even show that there are two people in the car that's driving away?
The video doesn't show who's in the car specifically, but again, we know that
Does it even show that there are two people in the car? As opposed to, it could be just the shooter in the car?
No, it doesn't. But we know that it's not just the shooter because, again, the GPS pings for the Acadia between 9:43 and 9:46 in the morning outside of 85 Deering Road, which is the same time frame when we see the shooter walking past 56 Deering Road and then immediately after the shooting sprinting back up in the direction of Wellington Hill.
So
to where-
what's relevant is the driver's state of mind at the time the shooter leaves the vehicle, correct?
Correct, his shared intent.
How do we know that, what's the evidence that the driver knew the vehicle was multiply occupied as opposed to just having a sole occupant in the victim car?
The jury could reasonably infer that from the fact that one person emerges from the car.
That's kind of a circular argument, right? So there has to be one person unless it's a self-driving car, but there has to be one person in the car. But how do we know that when they're following the car, that they know, there's two people, better get your gun or whatever lethal intent? How are we getting there other than speculation and guesswork?
So we know that from the shooter's direct path to the Lexus and his limited time on Deering Road.
That's when the driver's out of sight though, right?
Correct. So the Acadia has just minutes before, at about, again, 9:42 in the morning, past 56 Deering Road, heading towards Wellington Hill. A minute later, he's at 85 Deering Road.
Is there evidence that the driver of the Acadia drove past in visual, in sight of the victim car, or is it just tailing it?
Yes, the jury could infer that because, again, the Lexus makes a right-hand turn onto Deering Road at about 9:39 in the morning. The Acadia then turns right onto Deering Road, which is a one-way street, at 9:41:30 in the morning.
Okay, so he's behind him.
Correct. He's about a minute and a half behind. Deering's a one-way street, and we see on video the Acadia driving past 56 Deering Road at about 9:42 in the morning, and we don't see the Lexus ever pass that. The Lexus never goes north of 56 Deering Road, and that's also corroborated by Darrell's testimony that they parked outside of 40 Deering Road. So just briefly turning back to the other issues, in terms of hunting the victims before the murder, this is very similar to Watson. If anything, it's much stronger because we have 2.5 hours CSLI and GPS corroborated by video showing that the Acadia is circling Mattapan Square. And we know that at the very latest, the jury could have inferred that the defendant saw the victims as they left Brothers at about 9:31 in the morning as he's turning off Fairway.
Could I go back to this, the hunting though? So the hunting presupposes that it is Mr. Say that's the driver of the car, and you heard your brother still, he contests that you were able to prove that. And considering the delay from when it was rented to when this actually went down, why is that a reasonable inference that it is the defendant that happens to be in the car versus giving that phone, which acted like a fob, to somebody else that might have intended to participate with the person in the car to do so? In your brief, you say that one of the factors in favor of that is that he didn't live in the state, that he's a Rhode Island resident or went back to Rhode Island. Is that really enough, considering there's 2 days that elapses from when the defendant rents and returns it, that it couldn't have been given to somebody else? That it's a reasonable inference that it was him?
It's a reasonable inference that it's him because it's unreasonable that someone would give their cell phone, which this court has said in Almanar, that a cell phone is essentially a proxy for the person. It's unreasonable that someone would give their cell phone to someone else for hours on end, and that's what we have here. We have the GPS corroborated by the CSLI for 2.5 hours. And then again, shortly after the murder, we have the CSLI and the GPS tracking each other, corroborating each other, in addition to calls before and after the murder, as that car is traveling northbound up 93 and then is in the area of Haymarket. And then minutes after the Acadia is returned, we see the defendant alone walking out of the government center garage. And that's on video. But to Your Honor's point, the fact that he's from Rhode Island makes that case different from cases like Baxter, where the defendant was from the Roxbury area of Boston. So it could have almost been coincidence that the defendant Baxter was driving where he was at the time of the murder because he's from that area. It's more natural. Whereas here, this defendant comes from Rhode Island, specifically with a plan 2 days in advance, rents this car, includes all of his personal information, including his phone number, his email address. That's then verified by Maven, which is the rental company. It's a short-term 2-day rental, which allows him to rent the car from the government center garage and not even interact with any humans. And then again, in terms of after the murder, he's seen on video returning the car. Sure, it was returned that same day, but he returns it less than an hour after the murder. The jury could certainly infer that.
But doesn't his phone go off the grid for about a half an hour after the murder?
There's about a 25-minute gap, but the relevant point is that there's no video showing that anyone else that morning was driving the car. In that case, this makes it distinguishable from Gonzalez, where in that case there was evidence that the defendant's boyfriend had borrowed her car throughout the day of the shooting. And that isn't the case here, especially when we consider that the cell phone is used to operate the car.
How do you explain that gap, though, if the cell phone is used to operate the car? The car is in one place, then there's no information, and then suddenly the car is in a different place.
So what we know is that the last GPS point for the Acadia was at 9:46:32 in the morning outside of 85 Deering Road. That's about 25 seconds after the shooter is last seen passing 56 Deering Road heading towards Wellington Hill Street. And it's about 20 seconds after police arrive at passing by 56 Deering Road. So we know that by the time police arrive on scene, the Acadia's gone and the shooter's gone. And that's because Officer Burke testifies when he arrives at the intersection of Wellington Hill and Blue Ave, and Deering, he's looking and he doesn't see anyone running, he doesn't see any cars.
But what about the gap, though? Because if you need the phone to operate, what about the gap? Because the only testimony that I came across that talked about the expert testimony that was offered on this particular rideshare app was you might lose the signal if you're going into a tunnel or something else, but they're on Deering Road in Mattapan, and if their return point is Government Center, what accounts for where that car is if the fob is the phone?
So we know that there's this gap, but we know that there's physical distance between where the GPS last pinged at 9:46 in the morning outside of 85 Deering Road and where it next pings at 10:11 a.m., which is in the area of Mattapan Square. The jury could reasonably infer that the defendant traveled to that area. But regardless, we have corroborating CSLI and GPS from that point, 10:11 in the morning, consistently until 9:43 in the morning when the car is returned. After the car is returned, about 50 seconds later, there's a final phone call. And the phone evidence goes towards the fact of participation similar to Javier, where we have calls before the murder, no calls during the relevant time. And Javier, that was about 15 minutes leading up to the murder. And here it's from 9:34 in the morning
Well,
until...
your contention is not that he's the shooter, right? If he's the driver, he can be sitting in the car with the car on. But the shooter, and the shooter is a skinny guy. He's a 300-pound guy, right?
Correct. There was never any dispute that the shooter was a different person.
I'm confused by your last point then. So he's not running around shooting anybody. He's driving the car.
Correct. And so the lack of cell phone evidence from 9:34 in the morning until the shooting, shows his active participation. And that's when we see about 9:33 in the morning is when we see the Acadia turn left off Fairway onto Blue Hill Ave. It's passing the Lexus, which is parked outside of the post station outside the post office, excuse me. And we know the post office is slightly north, slightly more inbound than Brothers, which is where they had just gone to get their breakfast. And from that point on, they're aggressively following the victims.
Can I just want to summarize in my own head, your way of distinguishing Baez and Baxter on lethal intent is there was more tracking and there was one shooter and two victims. Is that essentially your argument for distinguishing those two cases?
Essentially, I'd add a little more in terms of the reconnaissance and then the aggressive following. In Baxter, we don't have that reconnaissance. We just have following for a shorter period of time. It almost seemed about like 2 minutes from reading the case. And again, the fact that the shooter and the victim are one-on-one and both are on foot in those cases, whereas we don't have that in this case. And so it's reasonable to infer that the defendant, again, remained outside of 85 Deering Road, which was beyond the crest of the hill, and also in a position similar to Watson, where the Lincoln was used to block the street. Here, he positions the car on a one-way street, having just made that U-turn in front of Morton Street.
But he's out of sight of the shooting, right?
He's out of sight, but he had just driven up Deering Road.
Because in Watson, he blocked the street. I mean, that was the difference in lethal intent in Watson, where he blocked the street, the guy gets right out of the car, shoots him, and then gets back in the car with a gun. Here we have the defendant parked out of sight over the crest of a hill, similar to the geographic issues in Baez and Baxter, right?
Yes, but my point in terms of the positioning of the
I don't
car.
think Watson helps you because Watson, they're right there at the scene.
Well, in Watson, this court, I understand what Your Honor is saying, though in Watson, what this court says is that the car positioned the Lincoln to block anyone else from interfering. And my point here is that having just made the U-turn on Blue Hill Avenue, passing the police station at the intersection of Morton Street and Blue Hill Ave, the jury could reasonably infer that the defendant positioned the car to quickly get away and avoid any interference from police, where we know that Deering's a one-way street and that the police station is on this specific corner that they had just driven past upon turning onto Deering Road. I see that my time has expired. Unless the court has any further questions, I'll rest on my brief.